we're going to be breaking down a fascinating legal memorandum that really forces us to examine the absolute boundaries of the Eighth Amendment. Welcome to This Explainer. Today, we're diving straight into the chilling intersection of a severe medical crisis behind bars and constitutional law. We're going to be breaking down a fascinating legal memorandum that really forces us to examine the absolute boundaries of the Eighth Amendment. It's one of those documents that makes us look hard at what happens when the justice system and a rapidly failing human body collide. Okay, I want you to start by just considering this number, 207. Imagine being trapped in a locked facility, completely unable to just pick up a phone and dial 911, all while your heart is racing at an astonishing 207 beats per minute. This isn't some hypothetical scenario either. For the subject of our explainer today, this terrifying reality actually led to a 30-second episode of complete unresponsiveness, literally a total bodily collapse. So let's get into part one, a life-threatening reality. What we're exploring in this memo isn't just your standard request for early release. It's an urgent plea based on a very harsh, objective medical reality. For an inmate named Carl Wages, everyday life inside the Marion Correctional Institution is framed as a totally unpredictable fight for survival. He isn't just dealing with one isolated issue. He's facing atrial fibrillation, which is an irregular heartbeat, right alongside hypertension, diabetes, and obstructive sleep apnea. The memo argues this is basically a cascading system failure, a complex web where one severe condition just constantly aggravates the other. And honestly, it gets even more precarious. This quote is pulled directly from his actual medical imaging results. Severe, greater than 70% atherosclerotic stenosis. To put that in plain English, it means he's living with a known catastrophic degree of carotid blockage. The main artery supplying blood to his brain is severely choked off. Medically speaking, that presents a massive looming risk of a major stroke, or for sure, even sudden death. Then we have the data pulled right from his cardiac monitor, which recorded 103 separate episodes of supraventricular tachycardia. Episodes where his heart is just beating abnormally fast. 103. Add that to the heart rate spiking to 207 beats per minute that we talked about earlier, plus ongoing arrhythmias and extra abnormal heartbeats. The document makes a very strong case that this sheer volume of cardiac events proves this is an active, ongoing emergency. His heart is basically in constant distress. Which brings us to Section 2, Systemic Failure and Delay. Now, the narrative of this memorandum shifts gears here. It moves from detailing a patient's bad health to putting a spotlight on the institution's response. This timeline breaks down a really troubling pattern of delayed treatment, as alleged in the source document. First, the patient presents with serious cardiac distress, but then months pass without proper diagnostic intervention. As a direct result of that delay, the patient suffers worsening symptoms and eventually collapses. And even after that terrifying event, specialist follow-up remains delayed. Obvious signs of distress were allegedly met with prolonged inaction. And because of these massive systemic delays, Wages isn't just sitting comfortably in a cell waiting for a doctor. Every single day, he's suffering from persistent dizziness, severe headaches, neurological disorientation, and tinnitus, which is this constant disruptive ringing in the ears. The memo emphasizes that he is being forced to endure a continuous state of untreated neurological instability every single day. All right, let's look at part 3, the constitutional threshold. This raises a huge legal question. At what exact point does inadequate medical care inside a prison cross the line and become a direct violation of the United States Constitution, specifically the Eighth Amendment? Well, to win medical parole on constitutional grounds, you have to prove the legal standard of deliberate indifference. It is a really high bar. It means it's not enough for prison officials to just be clumsy or negligent. They have to actually know about a substantial risk to an inmate's health and then consciously choose to disregard it. The memorandum actually maps out 3 foundational Supreme Court precedents to build its case here. First up, Estelle v. Gamble, which established that deliberate indifference is cruel and unusual punishment. For Wages, his severe conditions absolutely qualify as serious needs. Next is Farmer v. Brennan, stating officials must knowingly disregard the risk. The memo argues the officials clearly knew about Wage's collapse and that 70% arterial blockage. Finally, Blackmore v. Kalamazoo establishes that merely delaying treatment for obvious conditions violates rights, which applies directly to the institution allegedly ignoring his severe tachycardia and dizziness. But, the legal argument goes even further. Take a look at Helling-McMackeny. An unreasonable risk of future harm is actionable. This is crucial because it means Wages doesn't actually have to suffer a catastrophic brain-damaging stroke before a court is required to step in. Furthermore, Terrence v. Northville and Brown v. Plata establish that ignoring escalating symptoms and systemic medical failures fundamentally warrant release. The bottom line? The law doesn't require him to die or become permanently disabled just to prove his rights were violated. Let's move on to Section 4, Defining Deliberate Indifference. Let's really look at how the specific facts of this case aim to fit that exact constitutional definition. If we weigh the known severe medical risks, the carotid blockage, the 103 episodes of a racing heart, the literal collapse, against the prison's response, well, the response was months of delayed diagnostics, ignored symptoms, and inadequate vascular intervention. When you stack those risks against that response, the memorandum argues that the reality of deliberate indifference is undeniable. The risk was known and allegedly completely disregarded. Next up, Part 5, Rehabilitation and Public Safety. In the eyes of the law and the parole board, medical parole isn't just about failing health. It's deeply about evaluating the whole picture of the individual. Who is Carl Wages today? And what risk, if any, does he actually pose to society if released? The memo highlights his decades of positive institutional conduct. He's trained seeing eye dogs, logged thousands of hours of medical and vocational training, taught CPR, and assisted with children's charities. It paints a portrait of a man who has truly dedicated his incarcerated life to service-oriented behavior. So, these extensive rehabilitation efforts are used to effectively neutralize any public safety concerns. The court argument is that his release wouldn't endanger the public at all. Instead, it would simply allow a medically fragile man to get access to necessary, specialized, life-saving community care that the prison system has allegedly proven it just cannot provide. And finally, Section 6, the final plea. This is where we arrive at the memo's ultimate conclusion, the grand synthesis of the medical evidence, the constitutional law, and the human element, officially submitted to the state by Jenny Eversole Wages. It all comes down to these 5 pillars demanding immediate medical parole or compassionate release. 1. His life-threatening conditions are actively worsening. 2. There's an imminent risk of catastrophic harm. 3. Adequate care has been consistently denied. 4. He poses minimal danger to the public. And 5. He has demonstrated extensive rehabilitation. I'm going to leave you with this final, urgent question drawn straight from the heart of this memorandum. When an institution fails to treat a failing heart and a blocked artery, does keeping that person locked away serve any legitimate purpose for society? Or, through deliberate indifference, does it quietly transform a standard prison term into a constitutionally impermissible death sentence? It's a really profound question about how we define justice and cruelty in the face of total medical collapse. Thank you so much for joining me to explore this complex and vital topic.